Hey, Chad.
How are you?
I am good. I was like nervous if this was gonna work or not.
Yeah, I was on my computer, but I guess you got to be on the phone, so or through the app. So
Oh, really? Is that what it was?
I think so.
Thanks for joining me. You know, when I asked you to do this, I did not realize it was gonna be Easter morning.
All good. Happy Easter.
Happy Easter. You're like the best sport to show up at 9 o'clock on Easter morning to talk to me about divorce and bankruptcy.
Happy to do it.
So Chad and I have been friends for a long time. We went to law school together and we've worked with each other on quite a few cases. I mean, the reality is that one of the major contributors or reasons for divorces is financial issues. So a lot of times these things go hand in hand. And I always, as soon as people start talking bankruptcy, I'm like anxious and nervous and like, you got to get a bankruptcy attorney involved because I don't want to do anything without having their input on it. So I know one of the questions that comes up a lot is like the timing of filing for bankruptcy versus divorce. So will you talk a little bit about the timing piece of it?
Absolutely, and thanks for having me on. So when you're going through divorce, obviously a main reason for divorce are financial issues, and I know you see that all the time. What I recommend to most clients, and obviously it's very fact specific, but get the debt taken care of beforehand. Also, it's really important to file bankruptcy before you get the divorce, because once you're divorced, you get rid of some exemptions, specifically the tenancy by the entireties exemption. So if you have entireties property that you own as a married couple, even if you're separated, if you're not legally divorced, that property can still be exempt from individual creditors. So it's really important to speak to a bankruptcy attorney immediately if you're having financial issues and you're going through a divorce.
So tell me this, like, because I was just in mediation last week, and these were not my clients, but there were two attorneys there. There was a pretty significant amount of credit card debt. The credit card, some of it was about 30, 40,000 in the husband's name and about 60 or 70,000 in the wife's name. Now, for divorce purposes, all of that debt is marital. So we're sitting in our mediation talking about how we're going to divide it up. But I have the husband saying to me, well, it doesn't really matter anyway, because once this is all said and done, we're both filing bankruptcy. We've both talked to bankruptcy attorneys. So I don't care how much I keep in my name or what she keeps in her name. Is there like any validity or accuracy to that kind of thought?
Well, yes, but you have to be careful because remember, bankruptcy will get rid of credit card debt and will get rid of many different kinds of debt. But if you're taking on a responsibility from a marital settlement agreement, that responsibility would be non-dischargeable in bankruptcy. So I wouldn't trust necessarily that the other person is going to file bankruptcy until you actually see the papers. Because if you agree that you're going to pay that debt, then you file bankruptcy, well, you still have to pay the person's debt because the marital settlement agreement is non-dischargeable.
Okay. So does that mean that any of the debt that's allocated to you in a marital settlement agreement, you cannot charge off in bankruptcy? Or is that only if it wasn't in your name to start with? Does it matter whose name it was in?
Yeah, remember that the credit card companies don't care about the marital settlement agreement. So if it says the husband's supposed to pay it, but the wife is the one that's liable for the debt, the credit card company is going to go after the wife.
Okay.
And vice versa. So if the credit cards aren't paid, they're going to sue the person that was liable for the debt. So if the marital settlement agreement says that the husband has to pay it, if he doesn't pay it, they're going to sue the wife, and then the wife is going to have to go back to family court and then sue the husband to get that money to pay for the credit card debt.
Yeah, that's what I outside of the context of bankruptcy, I tell people that all the time when we're doing a divorce. If I can keep you with the debt in your name and the other person with the debt in their name, it's the best way to go about it, because at the end of the day, if the husband is the person on the contract with the credit card company, that's who they're going to come after. And if the debt was allocated to the wife in the divorce and she doesn't pay it, then the credit card company's still coming after the husband, and the husband's now going to have to go, and it just becomes this big triangle of lawsuits to try to figure things out. So I'm going to challenge your memory here for a minute without sharing facts that would give anything away. So a few years ago, you and I had a case together. It's like a business guy that you were helping in a bankruptcy, and you had gotten him in touch with me, and I represented him in a modification thing. So the guy at one point made like really great money and had a pretty significant alimony bill that he had to pay regular and ongoing. Sorry, crashed. Yeah, I have Chuckle's little miniature over here, actually, little mini Chuckles. So anyway, the guy, like, something had happened. The business had kind of fallen apart. It was a weird business, though, where it was like falling apart. He needed to file bankruptcy in order to save the business so that maybe it could come back. There were all of these components to it. And there was something interesting that came up in that case, that his bankruptcy actually could not proceed unless we had an order from the family court that basically abated or stayed his alimony obligation. And I thought that was the first time for me that this alimony component of bankruptcy had come up. So can you like fill me or everybody in a little bit on how those two things play together?
Yeah, so
do you remember that case, by the way? Do you know what I'm talking about?
I do. And in cases when there's reorganizations, and that's what this case was, so a Chapter 13 for an individual or a Chapter 11, we need finality on what the budget is going to look like. And obviously a big component of the budget was going to be the alimony. So without that number, and I think the judge said in that case, basically without having a finite number, it was impossible to put a 5-year plan together because that was going to be such a big component of the plan of reorganization. So, and obviously the bankruptcy court does not want to deal with family issues. So that's why they'll always kick it back to state court and you guys, because they have no interest in general in family law issues.
Yeah. So you were talking about with the Chapter 13, and you actually were like one of the early lawyers that I know that started doing some AI stuff. I am currently like obsessed with AI. So I ask AI about everything all the time. So I asked AI this morning to tell me a couple of fact scenarios that would be good to ask a bankruptcy attorney about divorce. And I also asked it to generate me just a random question for you, which I'm going to throw to you at the end, which was a funny one. But so it gave me two different scenarios. One is like Jane and John are getting divorced and they have a ton of credit card. Jane has a ton of credit card debt and she's thinking about filing for a Chapter 7 bankruptcy. And is her bankruptcy going to impact the divorce? And should she wait until the bankruptcy is finished before she files?
So the short answer is yes, the bankruptcy would impact the divorce. And I've had some family law attorneys come to me and say that they don't want their client to file bankruptcy prior because they're using that debt as leverage to get a better settlement, whether it's alimony or some sort of division of property. So it really depends on the exact facts. If both sides are doing it the right way and looking for the greater good, if you will, I would say file the bankruptcy, clear out the debt, and then divide the assets.
Yeah.
And just take that into consideration that somebody had to file bankruptcy, so maybe they deserve a little bit more of the pie, if you will. But as you know, many of these divorces can get messy, and people aren't really necessarily thinking, what's best for everyone. It's more of a more emotional decision that gets made.
No, I was gonna say, to me that seems like kind of not great advice for a divorce attorney to give, because at the end of the day, especially if kids are involved, like, you know, there is a family of people who have to figure out how to survive and move forward, and divorce is expensive in and of itself. And if you're coming into this with a bunch of debt that you're on the brink of bankruptcy anyway, it seems like you would want to clear out as much of that as possible and save as much as you can for everybody, rather than keep people on the hook with debt they may not even be able to discharge in the future because you want to negotiate. But that's me. So the next fact pattern that they gave me was Sarah and Michael are getting a divorce, and Michael is considering a Chapter 13 bankruptcy. And will this Chapter 13 bankruptcy have any impact on him or on his alimony obligations or the divorce settlement?
So with the Chapter 13, that's a reorganization where it's a payment plan over 3 to 5 years. The Chapter 13, again, looks at household income and expenses. So if they are separated, maintaining separate households, they don't have to look at their spouse and soon-to-be ex-spouse's income and expenses. So that's really important, especially for 13s, because if you're still living together, they still look at the household income and expenses, even though you're going through a divorce. But if you're living separate, then they don't. So the important takeaways from this scenario are, if your financial situation is going to change in the near future, that should be considered when doing the Chapter 13, because the Chapter 13 plan can lock you into a payment, and then if your rent payment goes up because you're not splitting expenses or something like that, you may not be able to afford that Chapter 13 payment in the future.
Yeah. It sounds like to me, for the Chapter 13, it may actually be better to file the divorce, but not finalize the divorce before you file the Chapter 13, because then you can get some of those temporary some of those orders in place regarding the finances. But because I think, correct me if I'm wrong, it's not the filing of the divorce that impacts anything in bankruptcy. It's a final judgment of a divorce that would impact something, right?
Correct. Final judgment, marital settlement agreement, those are what impact the bankruptcy.
Okay, Chad. Well, here's the question. Well, if I can find it, because it was really a funny one. Okay, so this is what ChatGPT has asked of you. If a couple's joint debt were a metaphorical bridge and their divorce proceedings were a raging river, would the bankruptcy petition be, or would the bankruptcy case be like building a sturdy dam or launching a flimsy paper boat?
Out of those two options, I'm going to go with the sturdy dam.
I was like, what is this? And I asked it about 10 more times, and I kept getting some variation of the same question. I was like, it's meant to be. I guess that's the question that I need to ask him.
Yeah, so I wonder if ChatGPT is going to say that I'm right, but I'll go with the dam.
Well, I would love to have you back another day to talk about ChatGPT and business stuff on our Boss Ladies podcast. But for today, I'm really appreciative of you showing up and talking about bankruptcy. And you always do an awesome job with and for our clients, and they're always very appreciative. So I'm grateful to have you around.
Well, thanks so much, Lisa, and happy Easter. Hope you enjoyed the day.
Happy Easter. Bye, Chad.
Bye.